Hello, everyone. We are proceeding with the second session. I'm taking interview with Matthew, Justice for Employment Insurance Misconduct. Matthew, thank you for being with us. The floor is yours. You can just continue your presentation.
Thank you. So before we continue, I want to just lay out two pieces of information that would be helpful. We are time constrained because of this recording. There's only so much we can do. So we're going to be sharing this PowerPoint with everybody that has a lot more information. And we also have a Substack set up, which I'm going to share on the screen here for a moment, which has a lot of information in it. Here, can you see it?
It's coming. Not. I just see a black screen right now. So double click to enter full screen mode. Okay, now I see it. Yes, now I see it.
Okay, perfect. So this website is justiceforeimisconduct.com. It's also linked in the PowerPoint, justice4eimisconduct.com. And we have a lot of resources in here. We've broken out, our factum was 180 pages. We've broken a lot of it out and split it. So, for example, we have court files and presentation. So you can get a copy of our court documents that we filed. You can see much longer presentations. We have a 5-hour presentation that walks through this case in great detail. And then we have short little clips that deal with the different errors. We also have a press release. If you know anyone that's interested in learning more about this, this is something that you can share with people. Here's an example of what it looks like. Short one page. And here is the meat of our case. We've broken down our factum into individual pieces. We just talked about the BE-Memo, so I'll show an example of the BE-Memo. This is our argumentation for it before the courts.
And again, as you say, BE stands for business engineering, which is a term which they use, I guess.
Yes, business expertise. That is the name of
business
the
expertise. Okay, that's a very interesting term altogether. Business expertise. Okay.
And then in here we have our arguments. We quote from the memo. We have footnotes. If you go to the bottom, we have footnotes that link to everything. We have links to the BE-Memo itself. We have links to the ATIP or the series of ATIPs that was used to uncover it. For example, we're going to be starting with an analysis of what does the EI Act actually require. So as you can see here, we have a lot of details where we walk through. There's hundreds of pages of Hansard, like parliamentary transcripts. We look at the EI Act in great detail. And if you go down to the bottom, you can see that we have 35 footnotes explaining this. So if anyone wants to know more about each individual section, there is a lot in there that they can use.
So the first question, which actually I have following our first presentation, what is your timeline? What is your plan? Where are you right now in the process?
So we are just waiting for a hearing date. We've had some back and forth with the court. It looks like our hearing will be a 2-day hearing in the second week of February, sometime between the 10th and the 13th. So that is still subject to approval from the Chief Justice. We should know by the end of next week. And then we will be publishing that information on this. So our Substack is free to join. There's a lot of information here, and we'll be publishing notifications with things like the public interest letter and more updates on our case once we actually hear back from the court sometime this week or next week.
And I know that presentations, court presentations, hearings are public. So I guess you will let us know when the date is or where it is, and people will be able to attend in person, and possibly even you could request a Zoom.
Yes, it will be over Zoom. Because it's not near us, we've asked the court for a Zoom hearing. So provided they approve our request, there'll be a public Zoom link. Anybody can attend. You have to register. You just have to put in your name and email address, and the court will send you a copy of that link so you can watch in real time.
Okay, so you will be presenting your case, the one which you are describing right now.
Yes, it will be my family member. Because I'm not a lawyer, I'm not allowed to directly address the court.
So he will be talking according to your points, like you are not allowed to speak there, right? So
correct.
Okay.
Pull up. One other thing, our email address is j4eim@outlook.com.
And that will include, I will include your contact information also in the video description. So the video already posted, the first session is already posted on YouTube. This one will be also posted there. And that will provide a link to it from my Substacks and from my electoral platform portal, where again, I do my best to support our union members, and your case is extremely important to many of them. So thank you again.
Thank you as well. So if anybody has questions, you can reach out through our Substack or email, and we will try and answer.
And by the way, while Matthew is preparing for his next presentation, also we are planning to have a Q&A session with Matthew probably next week around lunchtime. So we will invite everyone is welcome to attend and ask questions.
Thank you. So I'm going to pull up. I'm going to share my screen. Let me know if you can see. Share window, slideshow. Can you see the slideshow?
Yes, yes.
Okay. So one last point I want to list, and then we'll get into the presentation. One of the things that happened over and over during this is that the tribunal and EI decision makers kept coming back saying it's not within our authority to determine whether or not an EI, whether or not a policy is reasonable. And they had that in the template. They used that hundreds of times, saying that it's not our position to judge your reasonableness. And we actually agree in our case. We are making it very clear we are not challenging the reasonableness of a policy, because EI members can't do that. What we are doing is challenging the lawfulness of the employer's actions. And that is important because, as we're going to get into right now, that is a requirement. So here's where we left off. The first presentation was just highlighting a high-level view of what happened. We have two more parts. This part we're going to do right now is discussing what does the law actually say? What is required of EI decision makers? Now that we've seen what the problem is, once we see what is required of them, then we can get into, and how did they start engineering processes to get around this? They do not want to collapse EI and be left holding the bag. So here we go. We're going to look at what is required of EI decision makers. Briefly, in 1993, there was a Supreme Court case called Rizzo Shoes. It was an employment insurance semi-related case. In the Supreme Court, they came out with a new version, or a new way of testing how processes work. And in it, they said that the proper way to understand the law is to actually look at the entire law in its context. And that includes looking at what Parliament said when they were creating the law. And in that case, they actually went back to the parliamentary Hansards to prove what the ministers and parliamentary secretaries and directors of EI meant when they were writing the law. And they established that since 1993, the precedent is when you're making a decision that's based on a question of law, you have to consider the entire context of what Parliament intended when they wrote it. So there has never been a Rizzo analysis of this section of the EI Act before. So that is actually what we did. We spent a huge amount of time going through thousands of pages of parliamentary Hansards, pulling out what was actually meant by this. So a brief history of EI. In the 70s, EI was socialized for the first time. It was universal. So you could assault your boss, you still got EI. Then, of course, we have free trade, we have deindustrialization, and we have a collapse of our manufacturing base, which leads to a lot of financial problems in the 80s. That led to unemployment increasing significantly by over 50%. That led to a very detailed study. Both houses of parliament, the House and the Senate, conducted a 2-year investigation, which resulted in more than 4,000 pages of parliamentary Hansards, where they are discussing how are we going to deal with EI, considering we have a budget crisis, we have an unemployment spike. So in 1990, they came up with Bill C-21, and it did 2 important things. The first thing it did is it removed federal funding. So from the 70s up until 1990, EI was split 3 ways. It was paid for by the employer, by the employee, and also contributions from the budget from the federal government. They removed that because there's a huge budgetary shortfall. Now, it's important to understand at the time this was happening, 11% of people were on unemployment. So that means 1 in 9 of all adult Canadians were on unemployment. It was a very difficult time. So, of course, when you have a program that is already losing a lot of money, and then you withhold billions of dollars by saying we're not going to fund it anymore, you can imagine what happens, right? It came close to collapsing EI. The other thing it did is introduced this concept of just cause. During the 80s, 70s and 80s, in labor law, they began to develop this concept of just cause. In other words, if you lose your job, what are justified reasons for losing your job versus unjustified reasons? And it largely applied to settlements when someone was terminated wrongfully. So in 1990, they introduced this just cause into the EI Act, and it was just a short penalty. So if you did not have just cause, you would just lose a few weeks of your EI. So you still qualified, you just got less of it. So 2 years passed, so 2.5 years. We're now in 1993, and EI is in a crisis. They have now lost $1.7 billion because the unemployment is so high and they stopped paying out that it was going to collapse the system. So they released an emergency budget, and in their budget, they dropped some changes to the EI policy, which had never been done before, where you're changing how a program works inside a spending bill. And they dropped this change on the House the day before Christmas, the Christmas break, and they were supposed to vote on it when they came back. And that caused a huge controversy. It was the most controversial change in the history of EI. It resulted in many protests and sit-ins across the country. For instance, there was a 50,000 person protest in minus 25-degree weather in Montreal. It was documented 6 times in the Hansards that there were coordinated sit-ins at MPs' offices. The police had to arrest people across the country because of violence. When people realized, so this change they dropped in the bill was to deny someone EI without just cause. Again, up until 1990, if you had just cause, if you did not have just cause, you would just lose a few weeks of pay. This change they dropped in said, no, if you don't have just cause, you're going to lose all EI. You'll get 0. And it's mentioned throughout how controversial this change was. One example, it's mentioned twice, that the Minister of Employment and the leadership announced they were having to do construction projects, and at all the rooms used for EI adjudication across the country, they had to install back doors for the safety and security of the EI decision makers because this change was so controversial. It provoked a motion in the House, an emergency motion. It was extremely controversial. This change failed because of the public outrage. They came back 5 weeks later with a new bill called C-113, where they had the exact same changes before, If you do not have just cause, you get 0 EI. But they were forced to do two changes. They were forced to add 14 just cause categories to the law. In other words, if you had one of these 14 reasons for leaving your employment, you qualified for EI. And that 14 categories covered the 40 different reasons that were in labor law. They were also forced to add the benefit of the doubt to the claimant. So in other words, if there was a question back and forth and it wasn't clear whether or not someone qualified for EI, they had to be given EI up front. And then you go through the process. And if it turns out that you don't qualify, then they can take it back. But they said it's way too harsh to just deny people straight up when there's a question about whether or not they qualify and leave them hanging for months with no job, no employment, no money for pursuing this process. And that change did pass. So in total, over this 5-year period, there were 5 volumes of over 4,700 pages. This term, just cause, appears 545 times. It is the primary basis upon which EI is to be granted or denied. So for legislative intent, in our filings, we've included the statements of 10 ministers or 10 members of parliament from the party in government, 5 deputy ministers or ministers, 3 UI directors, and 2 parliamentary secretaries. And they were clear, unequivocal, that EI benefits cannot be denied to claimants who have just cause when separating from employment. And many of these quotes also make it clear, even in situations where the employer's alleged misconduct, you still have to do this just cause analysis. One of these 14 points is contrary to law. We'll get into that in a second. So here's Section 29 of the Employment Insurance Act. For the purposes of Section 30 to 33, which is the disentitlement part of the Act, just cause for voluntarily leaving employment or taking leave from an employment exists if the claimant had no reasonable alternative to leaving or taking leave regarding the following circumstances. And there's 4 we've argued, but one is the important one. Number 11 is when practices of an employer are contrary to law. If your employer is doing something unlawful and you can show how that directly leads to your separation from your employment, then you qualify for EI. And there's many cases up until 2020 where that analysis was done. I think an interesting side note is during the pandemic, they actually applied this contrary to law test for masks. So if people lost their job and they complained that the reason I left is because my employer is not forcing everyone to wear masks, then EI decision makers said, oh, not upholding mask mandates is contrary to law. You qualify for EI. So it shows a double standard, that they will do the contrary to law analysis when it penalizes the employee. But if it penalizes the employer, then they won't do that analysis. They'll say it's outside of our jurisdiction. And we have in our documentation on the website many examples of that. So the primary one is practices of an employer that are contrary to law. The 3 other ones are significant modifications of terms and conditions respecting wages or salary, significant changes in work duties, or undue pressure by an employer on the claimant to leave their employment. So I just want to read this again. Just cause for voluntarily leaving or taking leave. They're both there. There was a lot of debate over that wording, and they made it clear that both situations apply, whether you voluntarily leave or whether you take leave. You still have to do this just cause analysis in either case.
What's the difference between voluntarily leaving and taking a leave? Leaving, it's like you are forced, your employer put you on leave. Is it correct?
Yeah, so it's not defined in the law, but there's 2 ways to interpret it that have come out later. It can either be by reason or by scope. So I'll take the first one. Voluntarily leaving is I'm making a choice. I'm walking away from my job. Whereas taking leave is no, I'm not quitting. I'm not walking away. I'm just on a leave,
Okay.
like a leave of absence, which is where we were. The other way to look at it is voluntarily leaving is intentional. It's intentional. Whereas taking leave of, if I'm taking leave of something, it's not intentional. In other words, I'm leaving my employment, but it's not because I'm choosing to leave. Something is happening that is causing me to take leave. So in either situation, this wording here shows that both, whether it's by choice or by force, or whether it's by a permanent leave or whether it's just a temporary leave, both situations must be considered when you're examining whether or not something happened contrary to law or whether or not the employer made unilateral changes to your contract. And again, we have examples of many cases where this was done up until the pandemic. And then obviously something happened, and we'll get into the details why. But this is in statute. It is required by law. And all of a sudden, no, we don't have to do that anymore because of an emergency. It's not in our power to examine whether or not the employer broke the law. And they.
Okay, so let's move it to the next column.
So the next, there's one other section I want to look at in the DESDA Act. This is the act that sets the basis for the tribunal. For the powers of tribunal, the tribunal may decide any question of law or fact that is necessary for the disposition of any application made or appeal brought under this act. They may decide any question of law or fact that is necessary to decide the case. And again, that was widely cited before the pandemic. So under jurisprudence, I just want to show one case here. This is a case that actually came out during the pandemic in 2023, and it cites multiple federal cases, saying the term illegal and contrary to law analysis. The term illegal has a broader meaning than merely contrary to criminal law. It includes contraventions of employment standards, like the Canada Labour Code, legislation, collective agreements, and licensing board certifications, and they cite multiple federal court decisions backing that up. So when they're testing contrary to law, they actually have to, by precedent, look at, did they break labor law? Did they break health and safety legislation? Did they breach the contract? So how did they get around this? Because it's black and white, and precedent shows they were following it till the pandemic. And we'll look at how they engineered the processes. A quick note regarding contrary to law. There's a bunch of different ways that the law was broken. We have lockouts. So a lockout is defined this way: closing a place of employment, suspending work, or refusing to continue to employ an employee, done to compel them to agree to terms or conditions of employment. If they make a new policy and they say, we're not going to let you work until you agree to these new terms and conditions, it's a lockout. Canada Labour Code says lockouts are prohibited during the term of a collective agreement. And that's also in every collective agreement I've seen has a similar statement. Falsified records of employment. We will look at that in a minute. But it's a criminal code offense to willfully change the reason on a record of employment. Management rights is really important. In a contract, management rights is the clause that gives the employer the right to make policy. When you say that we cannot look at your contract because it's not part of our analysis, how do they actually have the ability to invoke management rights for a policy violation? And we'll look at it. There's Supreme Court precedents that shows, no, you can't do that. And of course, there are other violations of provincial laws, health and safety laws, consent laws, and so on as well. Before the pandemic, there was over 500 times that just cause analysis was done. So they knew that it was required. Also, before the pandemic, there were 365 cases that discussed the contents of employment contracts and cited different terms inside collective agreements when they were deciding whether or not to deny you benefits. Here's a section from the Employment Insurance Act. Section 51. When the Commission finds an indication from the documents that the loss of employment resulted from the claimant's misconduct, you must give them an opportunity to provide information and take it into account when determining your claim. That is right in the EI Act. Their policies define that. Evidence can take many forms, like written instruments, contracts, and collective agreements. Pertinent legislation, collective agreements, and employment contracts are among the evidence necessary to prove the facts of a case. So this is binding on them, both under the statute and their internal policy. We've already looked at lockouts. As far as contracts go, Vavilov, the Supreme Court says, where a relationship is governed by private law, which is employment contracts, it is unreasonable for the decision maker to ignore that contract in determining the parties' rights. So the Supreme Court also makes it clear, if the contract is involved, you have to look at it. You can't just ignore what the contract says when deciding whether or not to give the benefits. There's one more case we'll touch on, that's KVP. It came out of a labor arbitration decision in 1965, which the Supreme Court made binding precedent across the country in 2013. And it says, anytime that you are unilaterally introducing rules and they are not subsequently agreed to by the union, it must satisfy 6 prerequisites. We're just looking at 2. It must not be inconsistent with the collective agreement, and it must not be unreasonable, which includes unlawful. If something breaks the law, clearly it's unreasonable. In Irving, they came out and said any rule or policy unilaterally imposed on an employer, by an employer, and not agreed to by the union must be consistent with the contract and be reasonable. So there's no way out, no matter how you look at it. They're required to do this analysis. So this is a snapshot of the EI claims process. So it starts with something happens up here inside an employer that results in you being separated from your employer. Then you apply to Service Canada for EI. They make a decision, you reconsider. If you don't like it, the next step is going to the tribunal, which is a different body. And just like Service Canada has 2 levels, they also have 2 levels in Service Canada. There's a general division. If you're unhappy, you can appeal the appeal division. If by the time you get to the end of the appeal division, you still don't have an acceptable decision, then you can apply to the courts for judicial review. And now we're going to walk through step by step by step. How did they engineer the processes at each stage in this in order to make sure that people were denied access? And again, we have references to the various statutes. First one is record of employment. Everyone who, with intent to deceive, falsifies an ROE by any means is guilty of an offense. Section 398 of the Criminal Code. There's an ROE guide that is published by ESDC that explains how to fill them out. It says, it is a serious offense to misrepresent the reason for issuing a record of employment. If you knowingly enter a false or misleading reason, you may be subject to fines or prosecution. It also says use code N when the employee is leaving the workplace temporarily on a leave of absence. For example, taking any period of unpaid leave. Now, there was some confusion during the pandemic, so they issued a very specific document called Filling Out ROEs During COVID-19. Again, we have links to all this. When the employee does not report to work because they refuse to comply with your mandatory COVID-19 vaccination policy, use code N for leave of absence. And yet, we found that hundreds of thousands of people were given an M for misconduct, and it was knowingly.
So I wonder. We started this our first session with me showing response from the employer to one of our members, and the employer specifically wrote, we wrote M according to the instructions we have received, but it was administrative leave without pay. It was not in any way a discipline. So according to your knowledge right now, is it the employer who followed the instructions, received from somewhere telling them you need to use M, or is that so did they follow the instruction, or was there like another instruction which you are telling us they should have written N instead of M? So we don't know.
Yeah, we don't know. I can say this. The criminal code is clear. The ROE guide that's been around for 25 years is clear. Then, because of all the confusion during the pandemic, they released a document specifically about records of employment, and it confirms use code N. So if an employer put M and they did it knowingly, then they're violating the law. Now, if someone inside some department sent them an email saying you can, that's a different question. But I mean, if the law says something and the regulations confirm that, and a specific policy document confirms it again, like at what point can you excuse, oh, I found an employee inside Service Canada that told me something different? Is that justifiable?
So I have a question here, because you say it's a quote you've taken from somewhere. When the employer doesn't report to work because of the vaccination mandate, use code N. Did you get this quote from somewhere? Like, do you have a document which actually shows this?
Yep, it's linked right here, and you can see this document comes directly from ESDC. Everything
Because
in here is
because you know what? It tells me that for that my colleague, whose grievance case I was showing, I could possibly provide him a recommendation. Why not you follow up with your employer and tell them that they should have put code N? There is no way they could have put code M when the instruction, specifically the one which you're linking here, tells them to put code N. So I think this is already a little gain for all our members who are listening to us right now.
Yep, everything that is orange is linked, and you can see everything is directly linked to a government website. So this is not my theory. I am putting direct quotes from the authoritative sources. Now, there's a very practical consequence. ROEs are the only sworn evidence. That's really important. Box 22 on every ROE says, I recognize that it is a criminal offense to provide false reasons on this form. Every time you issue an ROE, you have to swear it's a certified document, which is why it's in the criminal code. Because of it, it's the only sworn evidence. So when the only sworn evidence says you've committed misconduct, and then you have your hearings and you say, yeah, but here's all the reasons why, they're relying on it saying, yeah, but that's not sworn under penalty of perjury. The ROE is, which has huge implications on the process, right? The only sworn evidence is a falsified ROE. Everything else from interviews and so on and submissions are not sworn. And there's significant impact on it. I'll just list two here. It avoids premiums. Under the EI Act and the regulations, if you are on a period of leave, on approved leave, and then you receive pay for that at any time, then EI premiums are due for that whole period of time. So if they put you on unpaid leave, and you grieve it, and the arbitrator comes back and says, yep, you should have been paid, you have back pay now, they're required to pay EI into that. So if you have a few hundred employees off for a year, that can be upwards of $1 million of EI premiums that is owed, that is not being paid, because by putting an M, they separate you from employment. And then how do they pay it back? By the time you go back to work, it's another year or 2 years later. You've already passed the reporting period for taxes. So you've deprived huge amounts of money from the EI program by separating someone versus putting them on leave. Also, there's a workforce reduction program. And again, this was also used in mass. If you reduce your overall numbers of workers permanently, this is meant for restructuring, and your workers are given a choice to voluntarily leave, they can be given code G. However, that must meet a bunch of requirements in the program. That was not met here because everybody was on a period of leave. So anyone who got a code G was still denied EI because of their misconduct. But meanwhile, the employer got huge credits on the back end for it. So let's look at the BE-Memo here, and we'll close off with this.
Yeah, we have 3 minutes and 30 seconds to finish this session, and I think it's becoming already very powerful evidence which you are showing us here.
Yep, so everything is linked, everything is on the website. The BE-Memo started with this title, EI Eligibility and Refusal to Comply with Mandatory Vaccination. The first line in the first paragraph said this memorandum is not linked to any legislative or regulatory amendments. So right off the bat, they're saying we're going to apply a special group of policies, but only to people who refuse to comply. And it's not based on any laws or regulations. It is strictly based on internal policy. And of course, towards the end, it said this guidance is to all staff involved in processing EI claims. And this memo unlawfully usurped parliamentary authority in a number of ways. For instance, it only applied to a specific subgroup. It didn't apply across the board. Because it was secret and not published publicly, it violated VAVA paragraph 95, which says that it is unacceptable for decision makers to expect their decisions to be upheld on the basis of internal records that are not available to the parties. So that, again, that nullifies their decision. There are many errors in the BE-Memo. It abused processes. It override defining. It changed definitions like exceptional circumstances that didn't exist anywhere. It just invented a subject and said, because of exceptional circumstances, we can change the law. It changed what it means to fact-finding by saying you're not allowed to look at contracts. Complete fact-finding does not include contracts when the law says you have to. They changed the definition of suspended and dismissal. They changed the definition of availability for work. So this is a very serious problem. When you're implementing a secret policy that forces decision makers at Service Canada to do something different than the law, and then tell them their cases will be escalated to management if you don't comply with this secret policy. And then that policy goes ahead and forces them to break the law. So again, if anyone wants more details, everything is listed in full on our website. They can read the memo, they can read the ATIPs, they can look at all of our arguments based on it. And they're all linked at the bottom here too.
Okay. So we have just about 1 minute. I think this provides a very good opportunity for some of our colleagues who have received ROE, which states code M. I think I could easily write another section for my self-representation that your next step is follow up with your employer and provide them evidence that they should have put code M according to instructions, and then request why they changed it, because then it becomes their legal responsibility. As you say, it's the only evidence, it's the only sworn evidence when someone puts a code on your record of employment. So this is very, very important piece of evidence, and maybe we'll start from here. And we will continue with your next presentation maybe next week. So thank you very much, Matthew. Amazing work, diligence in bringing